take out all of the chaff that they're trying to, the chaff and the shaft that they're trying to give you, you end up with something that says this act does apply to a person who is not a lawyer, who is a lawyer, and not a part-time judicial justice. Now, the question is it applicable to everyone? So, here what we're going to do, a little litmus test, and see which interpretation is proper. That's Humpty Dumpty. He's on his wall. If he falls down, all the king's horses and all the king's men won't be able to put him back together again. He's sad about that. Now, Humpty Dumpty, of course, represents the courts itself. And we must realize that amongst the courts, in the courts, there are judicial justices, JJPs, judicial justices of the peace. Some of them are drawn from lawyers, and some of them are not. So, we're going to have a JJP, well, actually, I'm going to go with the higher tech way. So we have two types of JJPs. Those who are lawyers and those who are not. Now, if we look at the Law Society's preferred interpretation of Section 1.1, and we don't operate on any assumptions, then the only people who are specifically excluded are, in fact, those judicial justices who are drawn from the lawyers. But what about the other ones? What about these boys who are judicial justices but not lawyers? Based on the Law Society's interpretation, you would have these judicial justices bound or not bound, and these judicial justices bound, for the only reason because these are drawn from the Law Society and these are not. That's a division that no public would be able to accept. It requires, in order to fix it, what they would then do is they would assume, they would try to use another assumption, and they would say, well, because this judicial justice isn't bound and they're all supposed to be equal, we'll just now make these not bound as well. That requires another assumption, and there's no reason for it because there's nothing in Section 1.1 that empowers or entitles them to do that, and it's not necessary to get to that point. Now essentially, folks, what the problem is, the Law Society, let's look at it in terms of a Venn diagram. Now, this, what we'll call, I will call this, if you're in this circle, you're bound by the Legal Profession Act. Now, it's my contention that only lawyers exist within that circle, and everyone else, all the public, is outside of it. And thus, we are simply not bound by it. Now, this is the reason when they draw a judicial justice of the peace from the public, they don't have to mention him in Section 1.1. He was never bound to begin with. Therefore, he doesn't have to be mentioned. However, those judicial justices who are drawn from the pool of lawyers and who are bound by the Legal Profession Act, those people drawn outside are, while they're acting as a judicial justice of the peace, not bound by the Legal Profession Act. However, when they're not acting as a judicial justice of the peace and they are acting as a lawyer, then they are, and they are a member of the Law Society, then they are in fact bound by the Legal Profession Act. Now, this situation means that the public is never bound by that act. Now, the Law Society doesn't like that interpretation. They prefer this, in fact. What they prefer us to believe is that in this circle, you have to be in order to not be bound by the Legal Profession Act, and that only judicial justices are in that circle. Everyone else is bound by the Act, and that would include the public. So what they see is one big circle within which the public exists along with lawyers, and judicial justices who step into this circle are no longer bound by the Act. The problem is, however, is that Section 1.1 only specifically mentions those JJPs drawn from this group of people, and it doesn't mention those drawn from this one. So then it would require a whole new assumption on the part of the determiner of the application of this Act. And the way I look at it, one speaks to freedom, and the other speaks to control. This one provides the lawyers with enormous control over the people in the country with very little remedy to those people, where the other one actually limits the lawyers and keeps them in their cage. I simply look at it as a different way, I guess. Now, in the end, they're going to have to accept one of two things. It's going to boil down to, hopefully, a judicial justice of the peace who has never been a lawyer making a determination and saying, okay, this is how the law society must operate. He's going to have to choose between essentially two options, two perspectives. The law society one is, within this circle is an exemption from the Legal Profession Act, and judicial justices of the peace who are drawn from the group of lawyers are exempt. Now at this point, only those drawn from the Law Society are going to be specifically mentioned, so their argument will be that they must assume, and here's their second big assumption, that all judicial justices, because they share the same level of immunity, must be granted that, and therefore they will then drag into this exemption the judicial justices who are not specifically